representing the appellant. At table with me is my associate, Stephen Fernandez. To begin, it is, as Your Honors know from the briefs, appellant's position that the trial court reversibly erred in granting Waffle House's motion for directed verdict, ruling that her claim in tort was barred by the exclusive remedy provisions of Chapter 440. For Chapter 440 to apply to Ms. Bason's accident and thereby bar her tort claim, it's our position that she must have either been preparing to work or engaged in activity incidental to her employment.
Well, Mr. Anderson, as it happens, this court, by either luck or some other twist of fate, is the court that hears all of the workers' comp appeals in the state. I think you can assume we're fairly familiar with the rules regarding when somebody is within the course and scope of their employment. Tell us how this case fits into that.
I will, Your Honor, and I'm familiar with that, having argued many cases up here in front of this court. Essentially, Your Honor, as you know, we have in workers' comp a concept called the premises rule. The premises rule extends coverage in workers' comp to employees who are injured while on the employer's premises within a reasonable time before or after employment, and they must also be either preparing to work or engaged in activity incidental to employment. Obviously, they must also be an employee to be covered. The premises rule is not a statutory creature. It is not a legislative enactment, but rather a concept that was created by this court by its decisions over the last 20, 30 years.
Or actually probably more accurately created by Professor Arthur Larson before he died.
I'll give this court some credit for adopting it then in the state of Florida. Yes, it does come from, as most workers' comp seems to come from, Larson. However, this court has never indicated that the mere fact that an employee is on the premises is enough to make an accident.
Explain to me how this case can be distinguished from the Johns case as it's in the application of the premises rule. It strikes me, although there's some differences in the facts, obviously, why, and that's a case coming out of this court, why isn't Johns controlling?
Well, I think Johns is not controlling for a number of reasons. One is the facts. Ms. Johns, as the facts indicate in that decision, routinely arrived, I believe it was 20 or 30 minutes before her shift. She'd wait out in, I believe it was the lobby. She had a fixed place of work, a fixed time of work, and her accident occurred. In this case, Ms. Bason, this was not even her regular business of employment. Though she worked for the company, she typically didn't.
But did she have any personal reason for being there other than her employment?
She had no personal reason to be there other than her employment. But that doesn't answer the question, Your Honor, on 2 points. One, whether she was engaged, as the premises rule requires, in acts preparatory or incidental to work duties. And two, whether she meets the statutory definition of employee. In the Johns case, you had a different definition of employee at the time that case was decided than you have had since the 2003 amendments to the workers' comp statute. Those amendments now require that the employee receive remuneration from an employer for the performance of any work or services while engaged in employment. In short, a person is not an employee under the current statute unless they are being paid for the performance of work and they are actually engaged in some work activity at the time of the accident is our position. And I think what this is a further clarification of the 1994 amendments by the legislature, after which this court in Vigliotti determined that the premises rule still had some viability based on the express language of the amendments at that time, and the fact that the legislature had not changed certain definitions within the statute. Well, now in 2003 they did. And so it would be our position, one, that she was not an employee as such as defined under the statute 2003 enactments, and that there's no evidence of record that she was engaged in any activity or preparing to work in any way.
If Go ahead.
No, go ahead.
If I understand that argument, the logical result in a situation where an employee has just punched out on the time clock and is walking out the door, the logical implication of your argument would be that that employee would not be covered by workers' comp.
Depending on your position, unfortunately, yes. I think that amendment to the statute raises some serious questions as to the continued viability of the premises rule, whether it truly applies in Florida anymore given the legislative enactments that have been adopted. And I would submit to the court that if this directed verdict stands in this case, what this court is effectively doing is extending the coverage of Chapter 440 to employees whom the legislature's intent, it seems, was to exclude them from coverage under Chapter 440. I'm not saying that's right. I'm not saying that's fair. I'm just saying that appears to be what the legislature has done.
If that's what they had intended, wouldn't they have been a lot clearer with regard to that intent?
With all due respect to the Florida legislature, Your Honor,
All right, yeah.
Okay. I think it is what it is. As someone who was up there during the 2003 session lobbying, I can, and this court hears many issues and will hear many issues on the statute. Intent is kind of a ethereal concept with the legislature. Even if this court were to conclude that the premises rule remains viable and that the argument could be made that Ms. Basin was within the course and scope of employment, we believe that the case law required the judge to submit that to the jury as the trier of fact for a determination, and that was not a question that the court should have decided as a matter of law. Absent any questions on the workers' comp and
how would that be a jury question? It seems to me that that's, I haven't studied it, but just off the top of my head seems to be that particular thing would be a pure question of law.
Well, Your Honor, there are at least 3 cases, 2 Supreme Court cases, and I'm going to probably butcher this name, but the Aloff case out of the 1st District, which suggests that it's a question of fact for the jury as trier of fact. And so we're arguing based on the precedent of this court and the Florida Supreme Court indicating it to be such. As I indicated, Your Honors, absent any other questions on the workers' comp, I'd like to switch to the attorney's fee issue, if I may. It's our position, as Your Honors know, that the proposal for settlement was unenforceable, being both ambiguous and having been made in bad faith. The proposal was made both under the statute, Section 76879, and under the Rule 1.442. And Rule 1.442 required Waffle House to identify the claim or claims the proposal was attempting to resolve and to state with particularity any relevant conditions. The case law is clear that a proposal for settlement has to be as specific as possible. It must be devoid of any ambiguity. And for this reason, as the Connell case indicates, 76879 is strictly construed in favor of the party against whom fees are being taxed. The proposal in this case stated it was to settle all of appellant's claims against the defendant, all of Ms. Basin's claims against Waffle House, yet the proposal did not specify if all of the claims meant tort claims or workers' compensation claims.
Well, it said in the above style cause, which refers back to a case number on the top of the pleading, I presume.
Well, I'm not sure if it refers to the case number or the style of the case, because the style of the case would be exactly the same whether we were in workers' comp or in circuit court, Your Honor. In this particular case, absolutely the same, because Waffle House is self-insured, so it is both employer and carrier in this case. In any case, it didn't state one way or another, and as a consequence, we believe it was not specific enough to support the award. We also do not believe that the proposal bore any reasonable relationship to the damages that Ms. Basin suffered. Her lost wages.
They may have reflected in what they regarded as a rather thin case of liability.
Well, if this proposal was intended, as we were not able to determine, to resolve both workers' comp and personal injury, the damages would have been substantially higher, whichever one is viable. because we had the evidence of record was that we have Ms. Basin being unable to return to any form of gainful employment, having physical injuries that preclude that. Waffle House was in a particular position to understand that because they had paid workers' comp benefits prior to Ms. Basin electing to proceed in tort. So they had a wealth of knowledge as to what the damages were.
Is it your position that a proposal for settlement under the rule must specifically identify any and all causes of action that the offeror might have against the offeree at any time now or in the future in order to avoid an argument like this?
I think if it's arising out of the same incident or transaction, yes, Your Honor, I do. And I think in this case where Waffle House clearly knew that if a tort claim was barred, Ms. Basin's remedy was workers' comp, that they could have made clear, as they did for the first time in their brief, that this was not intended to eliminate her workers' comp claim, but merely her personal injury claim. And that was not clear in the proposal. Lastly, Your Honor, we have the requirement for the trial court to address certain criteria under the statute, which I don't believe is clear from the judge's order in awarding fees that he ever entertained that. Now, we raised that in the context of a response to the attorney's fee, but there's nothing clear in the order that the judge ever considered any of those factors and their applicability to warrant a reduction. I'm sorry, Your Honor.
You argue in your brief that the financial condition of the appellant was a relevant factor. Do you have any authority for that?
Your Honor, I don't recall citing any specific authority for that. I've got to be
I've just
honest.
never seen that as a factor that is applied.
I don't think it's mandated by statute. I don't think the statute says this is one of the criteria, but I think it's a reasonable thing to do. You have an unemployed lady who has no ability to pay these damages.
Well, then
There's
she's
nothing
got nothing to worry about, does she?
Well, she really doesn't, to be perfectly honest, Your Honor. This is a hollow judgment if it stands, because I don't believe it'll ever be collectible.
But I think that Judge Van Nortwick's point is a valid one, because if that were a legitimate consideration, I would think over the years we would have seen cases, maybe not necessarily under this provision, but cases under attorney's fees shifting laws that said that was a valid consideration, because frequently in personal injury cases, as I'm sure you know, the plaintiffs have no assets to speak of, and so frequently in those kinds of cases an attorney's fee award against them is meaningless, and yet we never see that as a consideration.
Thank you, Your Honor. If I could, absent any additional questions, I'll reserve the last roughly
Well, let me
minute
just
and a half.
ask one really quick question. Your argument that the attorney's fee award should have been submitted to the jury, is that that's something I have evidently overlooked in the brief. Where is that?
The attorney's fee award?
Yeah,
No,
I
don't believe I've argued that, Your Honor.
Oh, I'm sorry.
I was arguing that
workers' comp, yeah.
the question of whether Ms. Basin was in the course and scope.
Right, I'm sorry. And that is an issue that was, that's the issue I'm referring to. That is an issue that was argued below and is also argued here.
I believe so,
Okay.
Your Honor. Thank you.
We'll give you a minute and a half for rebuttal.
Thank you.
Good morning. May it please the court. My name is Thomas Gonzalez. I represent the appellee Waffle House in the case before the court. We're here today to ask the court to affirm Judge Register's decision to grant a directed verdict and to affirm Judge Register's decision granting attorney's fees and costs. The court is very well aware of the law on workers' compensation statute. I agree that this is a case that is governed by the premises rule. I also agree that this case falls squarely within the confines of the premises rule, and what Florence Basin is suggesting would not extend coverage in the civil arena, but would actually abrogate 50 years of the premises rule as first set forth by the Professor Larson or the Florida Supreme Court in Cashman, as this court is in.
But Mr. Gonzalez, Mr. Anderson's argument, if I understand it correctly, is that a 2003 amendment has done that.
Yes, sir, and that's an interesting argument, and in fact, this is the first time, the reply brief was the first time that we've ever heard exactly how the 2003 amendment might have abolished the premises rule. Judge Register, I included as tab 3 of my appendix, the finding of the court when he granted directed verdict. And in that finding, Judge Register said, I've not received any case law or any statutory authority that would abolish the premises rule.
So you're saying that this argument was not made below?
First, I would say that is clear, that he has not preserved error on this issue. We said when plaintiff's case rested and we presented our directed verdict, we asked the court to direct the plaintiff to come back in with chapter and verse. Tell us, since he was saying a 2003 statutory amendment had changed the ground rules, we said, tell us, chapter and verse, how the statute has changed. The next morning, came in and said he was not able to find anything. That's when the judge issued the directed verdict saying, I've not received any citation to statutory or common law, case law authority that would show me that the premises rule is no longer valid. If you're allowed to say in a case like that, Judge, I know that the rules have changed, there's a case out there, then that's what every lawyer will do at any hearing. And then you get to go back after you're preparing your appellate briefs and look for some rule that has changed the statute. Here, he says that Ms. Basin says that the rule change is a change to the definition of employee. Well, the premises rule has been around and has been well enunciated for over 50 years. If the legislature had truly intended to change the premises rule, it would have been very simple to do it. They wouldn't have done it by some subtle change to the definition of employee. They did not do that. The case law still stands. And Judge Register cited the very cases that he relied upon in deciding that this case was a compensable workers' comp claim. The facts are so similar here to the Johns case, to the Cashman's case, but I think one thing that wasn't raised that needs to be pointed out is Mr. Anderson has stated that there was no evidence in the record for the judge to consider that Ms. Basin was preparing or performing work necessary to do her job. Ms. Basin was there solely for employment reasons. She left work early, or she left home early so she could get to the job and look around and familiarize herself with the area. At trial, page 128 of volume 1 of the transcript, she talks about going into the Waffle House, going behind into the employees-only area and looking around to see if there were any differences. I asked her, did you see any differences? Why were you doing this? She did, to familiarize myself with this area. Did you see any differences? Well, yeah, as a matter of fact, there's a right-hand grill in Chipley versus a left-hand grill. I went in the back, the coolers were in the same location. So from the minute she walked in, she was doing work, preparing for that day's work. She then went into the back to an employees-only area and ordered her free meal, the meal that's only provided to her because she is an employee at Waffle House, to get her through that shift. Now, she can't order a steak. They have limits to what they're allowed to order. She said she got the patty melt. She ate it at an employee-only desk. And she went through an employee-only area, out an employee-only back door, and smoked a cigarette. Now, if we believe this premises rule argument, that it's gone away, then when Ms. Basin was in that employee-only area looking around to see whether or not the things were the same and whether she'd be able to do her job the same way that she did at Mariana, if she had slipped in a puddle of grease there, she's doing work right then, getting ready for her shift. This new rule would say if she's not clocked on, she's not compensated. This case is so close to the premises rule, she was hit by the door of the premises when she was going back into the Waffle House to check the time to see if it was time to clock in. I don't know how you can be in any more preparation for the day's work or doing activities incidental to your work than going in to see if it's time to clock in. The Johns case, the Phillips case, the Cashman case, the Winn-Dixie case, Vigliotti, they're all cases that are so similar to this that it begs for application of the premises rule. and there's no indication in the 2003 or 1994 legislative enactment that would say that the legislature intended to abolish the premises rule.
You're not going to make the other side of this argument in her workers' comp case, are you?
I'm sorry?
You're not going to make the other side of this argument in her workers' comp case, are you?
I believe I'll leave that to one of my partners, Your Honor.
Okay.
On the issue of the attorney's fee award, the appellant argues that my proposal for settlement was ambiguous. It was interesting when Judge Padovano's question about what would be required under this standard to make a proposal for settlement that would satisfy the clarity that appellant demands. Counsel stated that, well, in this case, if it's arising out of the claim, then my proposal for settlement would be ambiguous. Well, that's an interesting statement because they have cited Nichols in their brief, and the Supreme Court has told us why the arising out of language in the Nichols proposal for settlement was the fatally defective language. In Nichols, a proposal for settlement was served that said, the proposal stated at the outset that it would be a, quote, a full and final satisfaction and settlement of any and all of Nichols' claims and causes of action in, comma, or arising out of, comma, the above styled case. Well, listen to the difference in what I said. This proposal is for settlement of all of Florence Basin's claims against the defendant in the above styled cause. In the above styled cause. I did not say arising out of. Well, courts sometimes put things in italics to let us know what they think is important. And in that Supreme Court case of Nichols, the Supreme Court said, although that claim, this was the Pitt versus a UM claim, although that claim was not technically in the above styled case, it could have been viewed as a claim, quote, and this is in italics in the Supreme Court case, arising out of, in italics, the above styled case, quote. They had a problem with the words arising out of. I did not put that in my proposal for settlement.
But Mr. Gonzalez, I think you'll agree with me that it could have been made more clear by simply adding a second sentence in paragraph 1 that read, it is not intended to impact her workers' compensation claim in any way, period.
And certainly I could have said it doesn't impact her workers' compensation claim. That is correct. I don't think that the law requires me to do that. I think that in the above styled cause, reference to the area directly above the page where it says in the circuit court in and for Washington County, Florence Basin versus Waffle House. Now, the whole reason for the proposal for settlement, we're not required to have a reasonable or repay Ms. Basin's future lost earnings or her medical bills or anything like that. The reasonableness goes to what is our assessment of liability. And now this kind of goes into the good faith as well as the ambiguity here, but I think the point is that they are intermeshed. At the time I filed the proposal for settlement, it was within days of filing a motion for summary judgment on the workers' compensation case that had not been heard, a 57105 motion claiming that the plaintiff's filing or for the plaintiff's claim for workers' comp benefits during the pendency of a civil action was causing Waffle House to defend on two fronts. The reason for the 57105 and for the proposal for settlement was to pick a cause of action. Are we going to go down the civil road or are we going to go down the workers' comp road? And that's the whole purpose of all of those filings back in March of 2005, 5 months before the jury trial. So in the context that it was there, it was not ambiguous, and it was certainly in good faith.
Why couldn't you, Mr. Gonzalez, assuming they had accepted this proposal, why couldn't you then have argued in the workers' compensation case that, look, we've already settled any claim she has for personal injuries on account of this accident, and we paid her in the civil suit?
Well, as you know, you can argue anything. I think it would have been a losing argument. The proposal for settlement was for the above-style cause, that portion that was in Washington County and Circuit Civil, You could make that argument in workers' comp, but it certainly would have been a loser. And we had, up until that point, Mr. Anderson has said we had paid workers' comp benefits. We had paid her medical bills. We had specifically stated when the original lawsuit was filed that we were not going to be, or that we asked the plaintiffs to stipulate that they were not going to claim that by failing to pay further additional workers' comp benefits that they would seek penalties against us. It was clear that these were two separate tracks.
And the settlement of the civil case wouldn't have been an election of remedies.
I don't believe the settlement of the civil case would not have been an election of remedies in the same way that if the court granting this directed verdict would not have been an election of remedies. I actually haven't considered that issue, but I don't believe it would have been. Nonetheless, we believe that Judge Register was correct in granting the directed verdict on the workers' compensation issue. We believe that the plaintiff has waived, or the appellant has waived the claim that the statute has changed by failing to bring it up before the court, the specific provision of the statute. We also believe that the judge was correct in awarding the attorney's fees and costs, and I thank you for your time, and I also thank you for allowing us this special day to go to accommodate our calendar.
Thank you. Mr. Anderson, we'll give you a minute and a half.
Thank you. And I want to address just 2 points quickly. One is the issue of the preservation of the issue. In the record, Your Honors, Volume 3, page 427, line 13, Judge Register specifically asked me, and I'll quote him, "I have pored over this, and unless you have, Mr. Anderson, some case law that tells me the statute as amended changes the general definitions of being engaged in employment, I'm required to grant the motion." And of course, as Your Honors are well aware, I'm not able to give him that case law and was not at that time. I did argue both at the directed verdict stage and then that the statute has been amended, that we did not believe she was an employee in the course and scope of employment.
Well, assuming it's preserved, can you explain now, and now that we're focusing on this a little bit more, exactly how this changes the law? Because I'm having trouble understanding how the performance of any work service while engaged, how that could possibly mean that the workplace injury has to occur at the precise moment somebody is actually working. I mean, under your interpretation, could a factory worker who's on his way to the men's room and trips, could you argue that, could the carrier argue that he's, no, you wouldn't argue that, could the carrier argue that he's not, they would, well, Judge, it didn't happen while he was working. I mean, isn't there a little room in this statute to do exactly what was done before, is what I'm asking?
I'm not sure there is, Your Honor. I don't necessarily think, though, that the individual who is on the clock, who goes to the men's room, is in a situation outside. He is still engaged in employment.
When you say while engaged in employment means while he's on the time clock.
The argument could be made that he is on the clock, he is technically engaged in employment, and he has a minor, if Your Honors know, deviation from employment to go to the men's room.
But if you had a person who worked an 8-hour day, got a half hour for lunch, but had to clock off at lunchtime and was not compensated for that, had just clocked off and walked into the break room to eat lunch, that person, under your interpretation, would not be in the course and scope of employment.
I think that is a reasonable interpretation of what the legislature intended, because if we don't do that, Your Honor, then the legislature's actual verbiage that they enacted has to be either rendered meaningless or limited, and you have to say it didn't mean what they say. That while engaged doesn't mean actually engaged. Now,
I'm having trouble believing even the Florida legislature would intend to be that draconian.
Your Honor, all I can do is cite you to the 2003 statute to answer that question for you. Lastly, if I may, and I believe Judge Van Nortwick, yours question was, could it be argued that the proposal for settlement would have settled the workers' comp case? And I think, obviously, that could have been argued by Waffle House after the fact, because the style of the case is essentially the same. The claims are the claims, and they use the term claims plural. They didn't say one claim from a one-count complaint based on negligence. They said claims. Well, she only had two claims, arguably, a tort claim and a workers' comp claim. So, thank you, Your Honors.
Thank you. We'll be in recess.